Ladies and gentlemen, welcome to Nuremberg, welcome to Courtroom 600. Wonderful to see you. It's my great pleasure to introduce the lecturer of tonight. My name is Viviane Dittrich, Deputy Director of the International Nuremberg Principles Academy. It is our great pleasure today to host Professor Gerry Simpson, who's an eminent expert in the field. He's a chair of public international law at the London School of Economics and Political Science, and also a fellow at the British Academy. He has published many articles which would not be able to enumerate here, but of course he's also the author of a number of prize-winning books, including Great Powers and Outlaw States, including Law, War and Crime, including War Crimes Trials and the Reinvention of International Law, The Hidden Histories of War Crimes Trials, Beyond Victor's Justice, the Tokyo War Crimes Trials Revisited, and Who's Afraid of International Law? He teaches public international law and international criminal law at the London School of Economics and Political Science, and was here fairly recently in Nuremberg at the international conference that the International Nuremberg Principles Academy organized in May 2018 on the 70th anniversary of the judgment of the International Military Tribunal for the Far East. So it's a wonderful pleasure to welcome you yet again here in Nuremberg, and we very much look forward to your lecture tonight with the intriguing title, 100 Years of Turpitude, a Century of War Crimes Trials. So without further ado, I hand the floor over to you, Professor Simpson, and very much look forward to the discussion afterwards. Thank you very much and welcome.
Well, thank you so much, Viviane, for that introduction. And thank you, Marianne, for setting up this trip for me. It's just such a privilege to be speaking in this courtroom. I think I've always had a sort of long-standing interest in the Nuremberg War Crimes Trials, which precedes my time as an academic and writer on this matter. So it's a double thrill to be standing here giving this talk today. So 100 Years of Turpitude, it's actually now 104 years of turpitude that I'm speaking about, because my story begins in 1915. This fitted better as a lecture in 2015 than 2019, but I think it will work here too. So I'm going to start really in a way towards the end of the story of international criminal law with a moment in New York in 2015 involving the then Foreign Secretary of Australia, Julie Bishop. And let me just read out a quote from the New York Times. Despite, and she's here in 2015 just after the downing of the Malaysian Airlines jet over the Ukraine in this particular period. So this is a quote from the New York Times. Despite an impassioned speech by its foreign minister, there was a failure to win Security Council support today for a resolution condemning the state for the downing of the airliner. Diplomats said they would have to settle for a less harshly worded statement. The interesting thing about that quote is it's not from 2015, it's from 1988, July the 14th. So in this report in 1988, the destruction of the airliner is described by the sponsoring state as an act of pure terrorism, a ruthless crime. But the state allegedly responsible for the act called it a tragic but understandable mistake. So in early July 1988, an Iranian Airbus, Flight 655, carrying 290 passengers, was shot out of the sky by two missiles fired from a US warship. The captain of the US warship was eventually commended for his action with a Legion of Merit. Soon-to-be President George Bush Sr. said on the election trail at the time, "I will never apologize for the United States. I don't care what the facts are." The International Civil Aviation Council, meanwhile, at its meeting in Montreal in March 1989, and I quote, deeply deplored the tragic incident which occurred as a consequence of events and errors resulting in the accidental destruction of an Iran Air airliner. Well, all of this in 1988 sounds awfully like the events surrounding the shooting down of MH17. But one very important distinction between the incident in 1988 and the incident in 2015, and it's a distinction that lies at the heart of my talk tonight, is that the Iranians in 1988 wanted a Security Council resolution condemning the United States. The Australians in 2015 certainly wanted that, but they wanted something else as well. They asked the Council to establish a war crimes tribunal to try those responsible for the deaths of the passengers. So the Security Council draft resolution in 2015 was very circumspect in its language, with the Council convinced that in the particular circumstances of this incident, the establishment of an international criminal tribunal is warranted, and deciding to establish an international tribunal for the sole purpose of prosecuting those responsible. I hope to show tonight that this particularism in the language of the draft resolution is a standard feature of war crimes law, and that it rubs up awkwardly against the apparent universalism of international criminal justice itself and the requirements of generality at the heart of the rule of law. Now, in less circumspect language, Julie Bishop said that the failure to establish a court would be an insult to the memory of the dead and an affront to the survivors. Nothing less than war crimes prosecutions would satisfy the Australian government and the Australian people. There must be no impunity, she said. The Russians vetoed the resolution, naturally, and the Russian veto, as she put it, only compounds the atrocity. The Australian Prime Minister, too, called the Russian veto outrageous. Samantha Power, the US permanent representative to the UN and the author of a well-known book on war crimes and genocide, described the attack as heinous and the use of the veto as tragic. Well, it's doubtful that too many people listening to the radio broadcast of Miss Bishop's speech would have found much to disagree with. After all, who could disagree with a call for justice? So here we enter the literary part of the presentation. In Sloane Wilson's novel, The Man in the Grey Flannel Coat, a Judge Bernstein receives a phone call from Schultz, a man demanding justice. Once Schultz gets off the phone, Bernstein reflects on the call. How violent Schultz had sounded over the phone. "I want justice," he had said. The judge then reflects. "I wonder how many murders have been committed and how many wars have been fought with that as its slogan. Justice is a thing that is better to give than to receive, but I am sick of giving it." Meanwhile, another magistrate in John Cotzia's Waiting for the Barbarians has spent his life administering law in a small fort at the end of an unnamed empire. When Colonel Joel from the State Security Services arrives to dispense justice in the form of lethal torture to two barbarian fishermen accused of terrorism, the magistrate too becomes sick of justice. "Justice," he says. "Once the word is uttered, where will it all end?" Later, Colonel Joel of the State Security Service discovers that the magistrate has a collection of barbarian scrolls. He then takes this to be evidence of treason, and the magistrate himself is then tortured. At one point, the magistrate is asked to read one of the scrolls. "See, there is only one character. It's the barbarian character, war. But it has other senses too. It can stand for vengeance. And if you turn it upside down like this, it can be made to stand for justice. There's no knowing what sense is intended." And John Brigg, the coroner in Ronan Bennett's Havoc in its third year, too grows weary of the endless calls for justice and correction. And like Cotzia's magistrate, Brigg ends up choosing the refuge of the road over the administration of law. So these novels are haunting studies about lives doing justice and the refusal in the end to do or continue to do justice. There comes a point, it seems, when doing justice, when one can no longer do public justice. the world won't allow it, or justice has become revenge, or the society has succumbed to what Judith Butler called penitentiary logic. These three works of literature then describe a world weary of the endless search for perpetual justice. And international law begins in this mode. In 1648, when the great European religious wars of the 16th and 17th century come to an end at Münster and Osnabrück, we have this from the Peace of Westphalia, the treaties signed at Westphalia in that period. And I'm quoting again, that there shall be on the one side and the other a perpetual amnesty or pardon of all that has been committed since the beginning of these troubles, and that all that has passed on one side and the other during the war shall be buried in eternal oblivion. So it's these amnesties and pardons, essential to the great diplomatic achievement at Westphalia, that are now so often deplored, of course, by Amnesty International and others when mechanisms are used, or when such mechanisms are used to shield human rights violators. Well, I want to offer a critical stock-taking tonight of a century of doing or attempting to do international criminal justice. And the central question, I think, can be posed in the following terms. Can international justice be done in this world? And I mean this in non-metaphysical terms. In other words, I'm not so interested in whether it can be done elsewhere, though this was one of the standard lines of thought advanced by the Nazi war criminals. Adolf Eichmann, for example, whose name comes up a fair bit tonight, demanded that he be judged before God and not before the District Court of Jerusalem. But let's bracket theological inquiry and ask whether the world is constituted in a way that permits us to do justice. To put this simply, is the international diplomatic system ready for international criminal justice? To put it even more simply, was the Nuremberg trial, for example, the trial of the century, as it was described by the newspapers, when the Allies, in Robert Jackson's famous phrase, stayed the hand of vengeance? Or was it, in the words of another judge, Jackson's U.S. Supreme Court colleague, Harlan Fiske Stone, a high-grade lynching party? Or was it something in between? So in the case of these magistrates in Bennett's and Cotzia's novels, the societies in which justice is being pronounced just seem too fragile, violent, radically unequal, and full of crazy superstitions to accommodate a form of law. This was the insight that the diplomats brought to Saxony in 1648. In a world where claims to justice or religious truth are pursued through violence, it's best that international diplomacy sets aside the claims of justice altogether and simply gets on with the not-so-simple task of making sure sovereigns at least get on with each other. Sovereignty, in this way, displaces or replaces justice. Now, Antonio Cassese, who many of you will, of course, have heard of, defended international criminal law by saying that some of it was better than nothing at all. And this is an absolutely standard defense of the imperfections of international criminal justice. Is it possible that instead some of it might be worse than none of it? Indeed, that a lot of it might be worse than none of it? And that in order to think about this, one must be attentive to the intimacies between law's violence and the violence that law is intended to repress. And alert, too, to the violence that law, certainly international criminal law, might be implicated in the perpetuation of. Well, at the very least, in my view, these are possibilities worth considering. But it's rather important that I say something else as well. The trial of Hussein Habre or of Adolf Eichmann represent moments of tremendous catharsis and perhaps healing for the victims of mass atrocity. So any critique of international criminal justice has to reckon with the enormous and entirely understandable emotional appeal of such trials. Well, let me tease all of this out by returning to Julie Bishop. There are a few things to notice about this tussle over MH17 between the Russians and the Australians. And these markers will appear and reappear as we move through the century of war crimes trials this evening. First of all, something really profound has happened to the way we think about the world. And I think this shift in sensibility can be felt in the differing responses to the 1988 incident and the present crisis, or the crisis in 2015. It now seems entirely natural to call for war crimes trials in 2015 or 2019 in a way that would have seemed altogether incongruous or diplomatically maladroit, even as recently as 1988, but certainly in the 19th century. And this reflects an adjustment in our thinking that dates back to the beginning of the 20th century. In essence, you could argue that we seem to be in a more retributive age now than we were at the end of the 19th century. Or at least that the mood of retribution now is much more juridical or law-based than it was at the end of the 19th century. So that what might have seemed entirely unnatural in 1915 has become utterly commonplace in 2015. Of course we punish our enemies in trials, haven't we always? And indeed, the language of war crimes law has become a primary idiom through which law is resisted too. So in 2015, to argue against the misery of war is to speak like a lawyer. In 1915, resistors spoke like poets. Now, serious violations of the laws of war, Article 3 of the ICTY statute, have displaced in our language what Siegfried Sassoon in 1915 called the butchered, frantic gestures of the dead. And one argument that I've been making over the years is that this may represent both a loss and a gain for us, this shift from a poetic language in 1915 to a legal language in 2015. So this leads on to a second aspect of the MH17 and Iranian Airbus disputes. Notice the way in which in both cases the injured state, Australia in 2015, Iran in 1988, cast the offense in the language of crime or atrocity, while the respondent state, Russia in 2015, the United States in 1988, preferred to characterize the event as a human error or a political misjudgment. And this, I think, too, sums up the way in which the move from the 19th century to the 20th century can be thought of in terms of a revolution in the meaning of what it means to be defeated in war. So what was once political folly became, at a certain point, a criminal act. Or as A.J.P. Taylor, the English historian, once said in response to the call for war crimes trials, states don't commit crimes, they make mistakes. So the 19th century we could call here the era of the mistake, and the 20th century and the century we're in now, the era of the crime. So that among the North Atlantic elites, decisions to go to war remain at worst mistakes in the 19th century style to be subject to administrative action. See the various inquiries set up by the British government into the Iraq War, Chilcot, Hutton and Butler. Or subject to electoral reversal, Blair, Aznar. But elsewhere, such mistakes quickly become crimes. See Gaddafi's war on Benghazi. So to put this much more rhetorically and a bit crudely, their mistakes have become crimes, while our mistakes remain mistakes. Third, it's worth attending to the silences and evasions present when there's a call for a war crimes trial. What is not being demanded might be a useful question. In the case of the MH17 incident, we might note that the Australians were not calling for a permanent tribunal to consider civil aviation terrorism. Or we might notice the lack of enthusiasm for a tribunal to look into alleged Sri Lankan killings of Tamils, or the destruction of cultural property in Tibet. So one encounters such proposals like the Australian proposal and thinks, well, why this? And why not that? And I think any institutional history of war crimes trials has to continually reckon with this question. So, with all that in mind, let me begin my stock taking of 100 years of international criminal law in 1915. It's always difficult to know when to begin a history of a particular field, and just as a preliminary point, one of the things I've noticed over the years is how international criminal lawyers have pushed the beginning of their history back further and further. So it used to be the case that almost every standard history of war crimes trials began here in 1945-46. Then the history was pushed back to Versailles, and that's where I want to begin. But of course, people have pushed back further than that to proposed tribunals in the middle of the 19th century in Syria, or indeed to ancient piracy as an example of early universal jurisdiction. But I want to begin on August the 3rd, 1915, with the court-martial of an English nurse called Edith Cavell. So Cavell had been found guilty of aiding Allied prisoners in their escape from Belgium during the German occupation of Belgium. She was convicted of a breach of German military regulations and an act of treason. Despite a flurry of diplomatic protests, Cavell was executed on the morning of October the 14th at the National Rifle Range in Brussels. The Germans, already accused, often falsely, of unspeakable crimes against the Belgian population, were immediately demonized further. Lloyd George went to the 1918 election with one of the most compelling election slogans in British 20th century history: "Hang the Kaiser." So the promise was made, and though the Kaiser remained resolutely unhanged after the war, this promise becomes the foundation for international criminal law. Kaiser Wilhelm died peacefully on June the 3rd, 1941, a month or so before Hitler's invasion of the Soviet Union. And these two events together, in a way, bring together two origins of the field, one at Versailles and the other at Nuremberg, where Hitler's march on Moscow is prosecuted as a crime of aggression. Back in 1918, though, at the Imperial War Cabinet meeting at 12 noon on November the 20th, Lloyd George is presenting his proposal to try the Kaiser for the crime of aggression. And the image on the right, the image on the left is a poster from an American film about the Cavell case. And part of the purpose of the film was to try to bring the Americans into the war. So Cavell became used not just to promote the idea of war crimes trials, but also to promote American involvement in the First World War. The image on the right is a meeting of the Imperial War Cabinet during the period of which I speak. So Lord Curzon, the Lord President of the Council, opens the meeting by remarking that there's no need even to argue for the trial of the Kaiser. He is, after all, the arch criminal, as Curzon puts it. Indeed, as Curzon reports, the French had not yet bothered to consult their own international lawyers about international law. No matter, the Kaiser could be put on trial and declared a universal outlaw. Indeed, Curzon goes on, wouldn't it be ideal to begin the League of Nations experiment on this note of trial and retribution? Lloyd George continues the discussion. With regard to international law, well, we're making international law, and all we can claim is that international law should be based on justice, and there is a sense of justice in the world. There's some resistance to this innovation, though. Billy Hughes, the Australian Prime Minister, is puzzled by the suggestion that the Kaiser be tried. As he famously puts it, well, why not Alexander the Great or Moses? Hughes' point seems to be that what we call now the crime of aggression used to be known as history. You cannot indict a man for making war, Hughes continues. And in a supremely evocative phrase, he equates the whole idea of criminalizing war with what he called treason against mankind. Well, Hughes is in the end outvoted, but not before he receives some support from the Ministry of Munitions, only there in an advisory capacity and standing more or less on the far right of the image. This minister, Winston Churchill, argues that the Allies would be within our rights to kill the Kaiser as an act of vengeance, but that it would be much more dubious to deal with him on the basis of what is so-called international law and justice. And indeed, Churchill remained attached to this idea in 1945 when he at first seemed to support summary execution for the defeated Nazi elites. So at Versailles, the law of war crimes begins with some familiar patterns. There's an anxiety about the relationship between revenge and justice, a cavalier attitude to the use of actual lawyers, a belief on the part of the proponents of the trial that the justice of the cause renders wholly unnecessary legal process and precedent. And the first sign that when it comes to war crimes and crimes against humanity, the identity of the perpetrators matters as much as the identity of the crime. Treason, of course, depends less on what is done and more on where one stands. And where one stands can be a matter of chance. Or as Lenin once put it, he went into one room and found himself in another. Usually, the history of war crimes trials passes over the interwar years in silence, so there's a straight move from Versailles to Nuremberg in many histories of the discipline. This was a period, after all, the interwar period, in which the efforts of progressives seemed to be directed at social and economic change through the League of Nations. But are the Moscow show trials perhaps the missing link between Versailles and Nuremberg? Historians of international criminal law tend to think of Solferino or the Hague Peace Conferences or German war crimes trials in Leipzig as the precursors to the trials in post-war Germany. Moscow 1937 is a pretty embarrassing antecedent after all. Judith Shklar defines show trials as the liquidation of political enemies using legal procedure. Well, Stalin knew all about that. But in that sense, he's not so far removed from Lord Curzon and Lloyd George. Establishing a tribunal for the specific purpose of liquidating or punishing an enemy. That's exactly what the Allies were doing in the Imperial War Cabinet debates in 1918. Of course, the Moscow show trials were very unlike the Nuremberg war crimes trials in many very important respects. But the idea that people's justice or humanity's justice or a sense of justice can somehow dispose of the need of proper legal procedure represents a sort of sibling dark side to these trials. A show trial is one in which it's obvious already that the guilty are guilty before the trial. The trial seems otiose, the mere performance of a justice already delivered elsewhere. Vyshinsky, the Soviet prosecutor at Moscow, was also at Nuremberg. During dinner with the judges at Nuremberg, he raises a toast. To the defendants, they will all hang. But this was before the trial had begun. Roosevelt, too, though, was worried about acquittals, and his concerns made their way into IMT Charter Article 19, the Nuremberg Tribunal Charter Article 19, which states, "The tribunal shall not be bound by technical rules of evidence." As one of the observers of the Moscow show trials yearly put it, these were dramas of subjective innocence and objective guilt. This objective guilt was repeatedly enunciated in the months preceding the major trials at Nuremberg, where the Nazis are repeatedly described as the world's worst criminals, and where the defendants were chosen with great care on the basis of the political impact they might make. The show trials themselves, of course, continued into the 1950s, most famously in Prague, where the purpose was not to determine guilt or innocence, nor even to remove political opponents, but rather to create them. As for the existence of legal norms, again, this didn't matter. The instincts of the proletariat would stand in for what Kirilenko, one of the Moscow prosecutors, called bourgeois sophistry. And this recalls to a Nazi law of June 28, 1935, referring to the need to punish criminals and deviants according to the sound perception of the people. 10 years later, though, President Roosevelt, as I said, was worrying about acquittals on technicalities. And Robert Jackson, pressed on the existence of crimes against humanity or aggression in the first place, replied by saying, "We can avoid these pitfalls of definition if our test of what is a crime gives recognition to those things which fundamentally outrage the conscience of the American people." This became, of course, at the trial, the idea of shocking the conscience of mankind. Mankind, of course, has now become humanity, just as the old language of enemies of mankind has been reworked as crimes against humanity. When someone at the Imperial War Cabinet asks what crime the Kaiser has been charged with, Lloyd George replies, "The crime of plunging this country into war." Sir Robert Borden, the Canadian Prime Minister, smoothly offers a gloss on this by interjecting that it was a crime against humanity. And there it is, the moment when the great powers begin to think of themselves as humanity rather than just a coalition of great powers. At least the victors at Vienna 100 years earlier merely thought of themselves as Europe. But the idea of crimes against Europe, while far more accurate as a description of extra-textual law, might seem too openly self-serving. Well, François de Menthon, the French prosecutor who stood here in 1945 and 46, invoked three distinguishable concepts of humanity. The first two were familiar enough, but the third and most radical concept of humanity saw it as a unified and indivisible category, a moral or juridical agent. The favored penalties of humanity, though, often come in forms of extreme violence applied to those outsiders, or those outside humanity. And there's an enormous amount of self-confidence when someone announces themselves to be acting in the name of humanity. So the French president at Versailles said, "Humanity can place confidence in you, the delegates, the victorious powers at Versailles, because you are not among those who have outraged the rights of humanity." But humanity here included the Belgians, French, and British, each of whom were by this time responsible for 3 centuries of sometimes violent, certainly racially inflected empire. Though the Imperial War Cabinet meeting on November the 20th began at noon, there was a lot to get through. The main line of business was the disposition of the Kaiser. What were the representatives of humanity going to do about this outlaw? But first, there were some minor matters to take care of. Here's Lloyd George again. There are 2 or 3 questions we are not clear about. Minor questions. Palestine, East Africa, questions of that kind, as he puts it. We have not quite settled in our minds what sort of government we want to set up in Iraq. It was ever thus. Here are the representatives of civilization and humanity just prior to elaborating the idea that aggressive war is a crime against humanity, reordering their imperial outposts. Themselves, as Justice Paul remarked at Tokyo, the results of 3 centuries of aggressive war. Well, mankind is, of course, shocked by many different things at different times, something the US advisors at Versailles argued when they resisted the whole idea of crimes against humanity, claiming that there was no such thing as humanity, only nations with different moral outlooks. In Jerusalem, Adolf Eichmann seemed unshockable. This is Nabokov, by the way, not Adolf Eichmann on the left, as most of you will have realized. And this is an image from the trial itself. So mostly when someone talks at a public lecture about Adolf Eichmann, there's a picture of Eichmann in his infamous box, his glass cage. It's sort of like the petty bureaucrat he's alleged to have been in some writings on Eichmann. But I prefer this image because it shows the Israeli public, utterly engaged, in fact, enthralled, enraptured by by the trial. In Jerusalem, as I say, Adolf Eichmann seemed unshockable. His thoughtlessness, indeed, was his most remarkable quality. Hannah Arendt said of Eichmann, the longer one listened to him, the more obvious it became that his inability to speak was closely connected to his inability to think. He was genuinely incapable of uttering a single sentence that was not a cliche. He seemed curiously affectless, in other words. At one point, he's handed some novels to read. One of them is Lolita. After 2 days, Eichmann returns the novel to the guards, visibly indignant. This is quite an unwholesome book, he tells the guard. Well, while Eichmann was running the final solution from an office in Berlin and then Budapest, Klaus Barbie was hunting down Jean Moulin, the French resistance leader in Lyon in 1942. That's Barbie on the far left. Barbie might have found Moulin in François de Menton's house, where he occasionally spent time. De Menton, the French prosecutor from earlier, at this time had become a resistance sympathizer. Barbie tortured Moulin to death, but de Menton went on to develop the concept of crimes against humanity at Nuremberg, a category of criminality that would be later applied to Barbie himself during his trial in Lyon in 1985. The Barbie case ought to be given its full name, though: the Federation of Resistance Fighters v. Klaus Barbie. This was to be the trial that established a judicial record of the heroism of the French resistance. There was a small problem, though. At 8:10 on the morning of April the 6th, 1944, Klaus Barbie had sent a telex to the Office for Jewish Affairs in Paris. It reads, "This morning, the Jewish children's home, the Colonie Enfants in Isieux, was cleaned. Total 41 children, aged 3 through 13 years, have been apprehended. Transport to Donsay to follow." The children were transported in manacles to Paris and then sent east to the camps. All of them were murdered. 2 of the boys were executed in Tallinn, Estonia. But the trial was a curious affair. What was it about? From the perspective of the French state, it was about the French resistance to Nazi occupation. Jewish groups in Lyon, needless to say, believed that the trial would provide some reckoning for Barbie's mini-Holocaust at Isieux. Barbie's defense lawyer, Jacques Vergès, later to defend Carlos the Jackal and Saddam Hussein, believed that the trial was an opportunity to embarrass the French state by pointing to crimes against humanity closer to home: institutionalized torture in Algeria, fascist collaboration in wartime Vichy. And so a problem emerged. From the perspective of the prosecuting state, crimes against humanity, in their now standard definition, were both over and under-inclusive. Over-inclusive in the sense that the broader one defined crimes against humanity, the more they threatened to encompass French colonialism in Algeria, something the French definitely didn't want. But too under-inclusive, and then attacks on civilians could not encompass Barbie's murderous behavior towards the French resistance. But as someone once said, every war crimes trial is saying at least this of the prosecuting state: we, at least, and whatever we have done or might do in the future, are not Nazis. And so crimes against humanity in the Barbie trial were defined as crimes committed in furtherance of a policy of racial discrimination, broad enough to cover the resistance crimes, narrow enough to exclude Algeria, where the French, at least, were not Nazis. Well, we might say that international criminal law went through 2 phases then, and that a modern denazified retributive legalism begins on May the 8th, 1997. The day that Duško Tadić, in the center of the image, is convicted of murder as a crime against humanity, the first non-Nazi to be tried before an international court in Europe since 1946, and one of the first non-Nazis to be tried anywhere for crimes against humanity. Or maybe this post-Nazi period begins a year later, when a set of human remains are subject to DNA testing in Frankfurt. this is my image of the DNA, by the way, on the far right, are subject to DNA testing in Frankfurt and determined to be those of Martin Bormann, the last Nazi, or at least the last of the Nuremberg defendants to be unaccounted for. Bormann's ashes are scattered in the Baltic, just as Eichmann's were disposed of in the Mediterranean. Well, let me come to some sort of conclusion here, and it will be quite a lengthy conclusion. Has modern international law somehow cleansed itself of the moral obtuseness and political opportunism of these early trials? The legal principles certainly seem much more transparent, yet the institutions still seem engineered in a way that makes even facially apolitical prosecution and trial unlikely. To situate the development of international criminal law in its historical setting, then, is to suggest that crimes against humanity do not simply exist in some supervening ethical space to be picked off by appropriately articulated rules. Instead, we might say, and sounding vaguely Marxist, that crimes against humanity are violent acts committed by enemies of mankind in concrete circumstances. So, in particular, international criminal law, properly anatomized, continues to be, in most instances, the law applied to enemies of mankind. Well, what should we make of all of this history? This is a matter that requires, I think, enormous delicacy. Thousands of people work conscientiously in the field of war crimes trials, investigating, prosecuting, helping victims, trying to reform the system, calling for universal forms of justice, arguing against great power immunity. Many more victims of horrible atrocities view trial as their last great hope for justice. No one can read about the moral strenuousness of the witnesses in the Eichmann trial or the personal anguish of a man like Hirsch Lauterpacht, struggling in Cambridge to develop a workable theory of crimes against humanity while his family disappears into the Polish and Ukrainian bloodlands, or the bravery of those testifying in the Balkan trials in The Hague. No one can encounter all this without stopping to acknowledge that the law of war crimes has become a site of great courage and the bearer of some of the ethical hopes of humanity. Yet there's something still awry with this system of justice. The history I've recounted leads to a possible conclusion that crimes against humanity are those crimes committed by enemies of mankind. Or let me put the two problems in this way. The identity of the violator sometimes seems more significant, decisive even, than the identity or nature of the violation. But more than this, the identity of the violation is already too narrowly imagined, creating morally suspect distinctions between different types of violence. So how should we respond to atrocity? The truth is, I don't really know. I'm not even sure that war crimes trials aren't sometimes the right answer. Maybe in North Korea, maybe in Colombia, maybe in Georgia. But law often is experienced as incongruous or technocratic or literal. Could it be that the more we memorialize through elaborate legal ritual, the less we're capable of remembering as a moral event? When Primo Levi, the Italian chemist and Auschwitz survivor, what he feared most of all on his release from the death camps was disbelief. In one of his earliest books, he describes a meeting with a lawyer shortly after the liberation of Auschwitz. The interview is marked between Levi and the lawyer. The interview is marked by awkwardness on the part of the author, and on the lawyer's side, incredulity. At the conclusion of the meeting, the lawyer gets up, shakes the writer's hand, and urbanely excuses himself. There was nothing the lawyer could do in the face of this survivor testimony. He could neither believe it nor find a legal response to it. Perhaps, if I had to sum up the argument, I would argue that we might consider sometimes electing the agonizing uncertainties of the author over the solemn and definitive judgments of international criminal justice. Unusually for a law journal, each front cover of the London Review of International Law features a different photograph. The 2015 volume had a photograph by Simon Norfolk from his series A Place of Refuge. And this place is a refugee camp on the border of Russia. Many of the people living there had been in the camp since 1999. It's a bleak place. But at the center of the photograph is an image of Malika Husanova and her family standing outside their military green tent. Surrounding the tent, though, is a formal vegetable garden, a mini Versailles, we might say, and a small gesture of hopefulness after atrocity. The story I told today begins near the gardens at Versailles, where the great powers in 1919 engineered one of the most transformative reforms in the international legal history, when war, for the first time in history, became crime. 20 years later, working outside another greenhouse, probably in Tavistock Square in Bloomsbury, Leonard Woolf was interrupted in his gardening by a call from his wife, Virginia. "Hitler is on the radio giving a speech," she shouts. Leonard calls back, "I shan't come. I'm planting iris, and they'll be flowering long after he is dead." Iris reticulate is a violet-colored iris. In the final sentence of Leonard Woolf's biography, with the very English title, Downhill All the Way, these irises are still blooming 21 years after Hitler's suicide. 9 months after Hitler's suicide, the Nuremberg war crimes trials began, right here, of course. In A Train of Powder, Rebecca West remembers being asked what was the most remarkable thing she had witnessed at Nuremberg. Well, she said, there was a man with one leg and a girl growing cyclamens in a greenhouse. And I've always imagined the greenhouse to be where that car repair plant is now, in front of the trial building. Well, as I've said elsewhere, the bathos in this, a sort of decentering of the trial, makes us smile. This little girl growing cyclamens is demanding our engaged sentiments, not our pitying tears. We want her horticulture to succeed. Here she is, growing cyclamens, only a few months after Bomber Command's final assault on the civilian population of this city on the night of the 16th and 17th of March, 1945, when 277 Lancaster bombers pulverized the remnants of the historic center of Nuremberg for the second time. Nuremberg, then, refers to the trial, of course, but also to the bombing and the greenhouse. Rebecca West sounds as if she's a little disaffected by the justice on offer at Nuremberg. And this mirrors the mood of Hannah Arendt when she goes to Jerusalem in search of justice and discovers instead spectacle. Well, in light of all this history, it's perhaps not surprising that international criminal justice, the great institutional machine engineered by talented and humane diplomats, kept in motion by lawyers who've sacrificed material reward for a life in pursuit of humanitarian ends, directed at putting defeated enemies and human rights violators in jail, and celebrated every week in a public lecture advertising its virtues, is entering one of its most difficult periods. Thank you.
Wonderful. Well, thank you very, very much, Professor Simpson. It's been an absolute pleasure to listen to your tour de force of the last century, really intriguing and interrogating numerous of the moments that crystallized the edifice of modern international criminal law as we know it today. You interrogated, obviously, the concept of justice, a number of the silences of the field, as well as the linearity or the non-linearity of narrative surrounding the development of international criminal law. So thank you very much for this wonderful illustrated lecture. Very, very many intriguing moments, and I think the next few minutes, we would like to use the opportunity to delve into some of the questions you raised, some of the dilemmas you raised that states faced, as well as other actors in the field, as well as scholars or commentators who observe and comment on what they have seen. So So allow me to start, and obviously we will open the floor to the audience in the course of the discussion. Allow me to start by inquiring about the choice of the constitutional moments. Are there a fixed set of constitutional moments? Was there a panoply? Was it difficult to choose those particular moments that you did decide to illuminate further? And what is their relative weight? In other words, is one silence in there, or is there a proactive choice that you said, oh, I left that out precisely because of a particular reason?
Yeah. Do you think we need these? Should we have them for the recording? Yeah, what a great question. It's a question I really ought to have anticipated, but no one's ever asked me it before. So the idea of constitutional moments comes partly from an American constitutional law scholar who you'll be familiar with, Bruce Ackerman, who thought the best way to study US constitutional law was through a series of moments of change. And that lawyers didn't tend to do this very well. We study the slow movement of the law through time, and he thought we might be able to figure out a better way of studying constitutional law through these moments. And I first applied this idea to a book I wrote on the great powers, or the history of the international diplomatic system, where I had a look at a set of very sort of standard constitutional moments. 1648 at Westphalia, 1815 in Vienna, 1918 at Versailles, 1945 at the UN. And I guess I was mimicking that process in this paper. But I also wanted to offer up what I thought of as a sort of counter-history, if you like, or an anti-history of war crimes trials, to try and tell a story of war crimes trials for the last 100 years through a series of moments which were not typically considered as constitutional moments, anti-constitutional moments perhaps, or had been ignored altogether, or couldn't even be recognized as international criminal law. So, I guess that's part of the answer. I don't know about the relative weight I would give each of these moments. I tend to think that this moment between 1915 and 1918 or 1919 is very, very significant for the history of international criminal law. That, in a way, international criminal law kicks off at Versailles, or almost kicks off at Versailles. It sort of stops in its tracks. I was once introduced in the Netherlands by, a Dutch government minister who was chairing a panel, and I was giving a talk on international criminal law, and he talked about how instrumental the Dutch had been in the history of international criminal law. And I stood up and said, well, actually, the Dutch stopped the whole business in its tracks in 1918, 1919 by refusing to surrender the Kaiser to the Allies. I mean, the Dutch felt that honoring hospitality was more important than honoring retribution. And that could be seen as a very, very noble move on the part of the Dutch government in 1918, 1919. And as we know, the Kaiser died peacefully, though unhappily, in the Netherlands in 1941. So I thought that was a rather interesting moment for international criminal law, both in the sense of what happened and what didn't happen. And because we have a certain penchant for looking at things that happened all the time, I was quite interested in the things that didn't happen. And then just before I ramble on any further with this answer, I'd say that Moscow 1937 is regarded as a rather incendiary constitutional moment for international criminal lawyers who like to track the history of the discipline through Versailles, Nuremberg, Tokyo, and The Hague. Moscow is, as I put it in the paper, a bit of a dark sibling or cousin to all of this. But I do think that it's not just the historical proximity of Moscow to Nuremberg that counts here. It's not even the continuity in the personnel. The same prosecutors at Moscow turn up again at Nuremberg. There's something about the way that both Moscow and Nuremberg gesture towards this sort of the conscience of the people, or the conscience of mankind, or the conscience of the proletariat. And it's something that Soviet law and international law seem to share. And even more provocatively, it's something that Nazi law shared with both of them.
I mean, you mentioned that the common refrain obviously is from Nuremberg to The Hague, or from Nuremberg to The Hague to, via Rome, for example. So I was curious, you didn't mention the Rome Statute, this 1998 moment, which for many is an iconic moment in the development of international criminal law. So I was curious if you could elaborate whether you would see that at all as a constitutional moment. How would it fit in, again, to this story of linearity, non-linearity, pointing out the silences, the history, the anti-history of international criminal law?
Rome, the Rome Statute, where the ICC was established, is a really enormously significant moment for the history of international criminal law. I guess if I was giving a talk to, say, a Rotary Club in my hometown, I would talk about the Rome Statute in 1998. In 1998, but talking to an audience already educated in international criminal law, I felt that moment was almost too familiar or too iconic. It's also the only moment where I was actually present myself. So maybe I've just grown a bit weary of the Rome Conference. And I did a lot of writing on the ICC statute and the Rome Conference around that time. I was at the General Assembly for a couple of years in the lead up to the draft statute and then the eventual statute that was put before the delegates at Rome. I was in Rome with the Australian government, and I guess I just feel as if I've, in a way, to a certain extent, said as much as I can possibly say about that subject. And so much is written on the Rome Statute. I mean, if you compared how much had been written on the Rome Statute to how much had been written about the Moscow show trials in relation to international criminal law, it would come out as about 7,000 to 2 in article numbers. Not that I've done the research on this, but.
Thank you. We're just briefly returning to your starting point, Versailles, which you rightly point out is oftentimes forgotten. Recently at an international conference here in Nuremberg, Klaus Kress, preeminent German scholar, also mentioned that this refrain from The Hague to Nuremberg needs that extension from Versailles to The Hague. And indeed, he very much pointed to the birth of the droit international nouveau, the new international law that was born precisely in Versailles. But briefly turning to Nuremberg, and obviously we are in Nuremberg here, so I think it feels fitting to briefly speak about this moment of Nuremberg before we'll come to the Nuremberg-Tokyo comparison shortly. I think a lot, of course, has been written about Nuremberg, and I think many have looked at what it actually means. I mean, Robert Jackson, indeed, in the opening speech, also was very conscious of history, passing a judgment then on those sitting in judgment. And I quote, he said, "We must never forget that the record on which we judge these defendants today is the record on which history will judge us tomorrow." So there was already this sense of gravitas, of the world is watching this enormously important trial. So I'd like to ask you, in light of some of the comments made about Nuremberg, Chavez pointing it as a turning point in human history, that it will be regarded in a few centuries from now, if it is not already seen as such a turning point for mankind or for humanity. How do you see that, again, this moment of Nuremberg fits in to the wider narratives of the development of the field in terms of this birthplace of modern international criminal law? Would you recalibrate that kind of founding myth, if you like, that is often, of course, reiterated and re-emphasized here? And how do you see it playing out from your perspective?
Well, I'm going to sound like a very good guest here, because I think that Nuremberg, whatever I say, or whatever anyone else says about international criminal law over the next 50 years, Nuremberg's already occupies the place as the central moment, the main constitutional moment in international criminal law, at least for our generation. I mean, I was speaking to my daughter about this, who's in the audience, and I think for the sort of younger 20-something generation, it may not be as well known. I think that's perhaps a major, we spoke about this too earlier on, it's a major task for you
here to educate a group of people for whom the Nuremberg trials may not loom as large as they did for me. I mean, I grew up during the Cold War, but I think most people in my school knew what the Nuremberg war crimes trials were, and they didn't know anything about Versailles, and they knew nothing about Tokyo. And I suspect even the Rome Statute won't be that widely known by school children today, but Nuremberg was a major, major moment. And I think when historians look back in 200 years, if indeed historians exist in 200 years, they'll see Nuremberg as, I think, the monumental moment of international legal history. But I've spent a bit of time in my work trying to decenter Nuremberg. And in some ways, you've done that here in Nuremberg itself. You held that trial. You held a conference on the Tokyo war crimes trials a year ago, which is all part of an effort to situate Nuremberg in a context beyond Nuremberg, to situate it in the Tokyo context, or the Versailles context, or the Rome Statute context. And that seems like a very, very important political and didactic and juridical exercise to engage in. But the last thing I'll say about the Nuremberg war crimes trials are that the difference between Nuremberg and Versailles, say, is that, of course, there was a trial here. I mean, there were many trials here. The Americans, of course, had their zonal trials in Nuremberg, and there is an enormous trial proceeding. When I was a student in Aberdeen in 1986, 87, I looked up one day from my desk and I saw a row of trial reports that just looked a bit unfamiliar. And it was actually the first moment in my life when I realized I needed glasses as well, because I couldn't read what was on these trial reports. And I went closer to them and realized that they were the proceedings of the Nuremberg tribunal. And I got one of these little chairs you get in libraries, or you used to get in libraries, and I sat down and I began reading one of them at sort of random, and it was, as I said, it was absolutely enthralling. I must have been there for about 2 or 3 hours, and I think it was my first exposure to the field of international criminal law, and possibly my first exposure to reading history in its archival form. I don't know what I was reading, even looking back on it. Was the cross-examination of Kaltenbrunner or something? Not something probably anybody really thinks about that much. But for me, there was a sort of living, breathing textual history came off the pages, and I suspect that's going to be the case whenever anyone picks up these proceedings in the next few centuries.
You mentioned Tokyo, and allow me to ask you, you've created a neologism, Tokyoberg. I'd be curious if you could briefly re-elaborate on this constitutional moment, the dual moment of Nuremberg and Tokyo, and in a nutshell, what you mean precisely by Tokyoberg. In other words, creating this neologism.
So I now call this constitutional moment Tokyoberg, and I'm hoping it gets taken up widely as a term. And I guess what I was trying to do is to put together the somewhat authoritative history of the events in the 1930s and early 1940s that one finds in the Nuremberg proceedings, with the slightly more eccentric, idiosyncratic judgments one finds in Tokyo, particularly Justice Powell's famous 900-page dissent at Tokyo, in which he acquits all the accused Japanese war criminals. And I think if you put together, in particular, these two sets of documents, you get a very, very interesting, subtle, nuanced, possibly contradictory picture of just what it means to participate in international criminal justice. But I think it's, to go back to a word you use, it's much more interesting than the sort of linear accounts that we're used to, where Nuremberg was a great achievement, it led to The Hague and Rome and so on. I think if you put together Nuremberg and Tokyo, you see both a desperate desire for a reckoning with Nazi evil, combined with a serious doubt that the history of European imperialism and colonialism just wasn't part of the Tokyoberg picture, apart from in Justice Powell's dissent.
Absolutely. Allow me to briefly come to one of your previous works, Law, War and Crime. You really, make a very, very interesting argument. You challenge the orthodoxy of war crimes trials being political trials in the way that they're often portrayed as political trials. And you say they are political not because they lack a foundation in law or because they are the crude product of political forces, but rather war crimes trials are political trials because concepts of the political remain perpetually in play. So you disentangle this then and produce 4 concepts of the political, and I'd be curious how you might map that onto these constitutional moments. Do you see a panoply of concepts of the political at play at each of these constitutional moments? Is there a particular dominant concept of the political that you might identify across the various moments that you have sketched for us?
Whoa, that's a really complicated question. I guess the answer, let me sort of offer a slightly cowardly, simple answer to that, which is to say that the idea that war crimes trials were political goes back to somebody I mentioned earlier on, Judith Shklar, the American legal theorist who wrote a book called Legalism in 1961 or 62. It was one of the very first serious jurisprudential studies of the Nuremberg war crimes trial. And her main point was the choice of a legal proceeding, the choice of a Nuremberg or a Tokyo or a trial in The Hague is a political choice. And to describe it as a political choice is not to discredit it the way many people do. They say this trial is political and therefore it's a show trial and therefore it's discreditable. Shklar was making a much more subtle point, saying when we choose trials, let's just be aware that we are choosing trials. Let's not think that the trial is imposed on us and we're the reluctant or willing recipient of law. Instead, we're choosing law. Legalism is a choice of law. I mean, as she put it in her book, Legalism, there are lots of different ways to deal with something like atrocity. You could deal with it through literature. You could deal with it through execution. You could deal with it through a Truth and Reconciliation Commission. You could deal with it through immunity or amnesty. You could deal with it through theater. You could deal with it through trial. And if you deal with it through trial, you're making an anterior political and cultural and ethical decision to use a trial proceeding in order to achieve some sort of justice. Not to say by any means that a trial proceeding lacks a literary or theatrical dimension. I mean, just speaking in here, you can sense the theater of the proceeding. You can imagine being in this courtroom and experiencing that moment in 1945, 46, and feeling that one was at the center of a piece of human drama as well as a trial.
Allow me briefly, before we open the floor up to the audience, I'd be curious, David Luban wrote a piece called The Legacies of Nuremberg and identified 3 particular legacies. 1, the crimes against the peace, crimes against humanity. 2nd, the rule of law. And the 3rd, threat of bureaucracies. Without going into further detail, I'd be curious, this notion of rule of law. Obviously, this year is also the 30th anniversary of the fall of the Berlin Wall, which opened up a new political space that this notion of rule of law was taken up in international discourse by international organizations. How do you see the interplay of these constitutional moments with the affirmation of the rule of law, also in light of the current political situations where we see a lot of rule of law backsliding within Europe, but also more worldwide?
Yeah, well, from a conventional perspective, the rule of law, it feels like the rule of law is in a lot of trouble. The idea of using legal and constitutional principles to resolve political struggle, it just seems so obvious to us for at least half a century. But, and I feel like I've got a kind of commercial duty to invoke Brexit at least once in every public engagement I'm involved in. But if you come out of a Brexit Britain, you realize what a fragile thing the rule of law is. It seems to me that the rule of law is a bit like an angel. Every time you declare you don't believe in angels, an angel dies. So when Boris Johnson, or indeed anyone, says, well, you know, this constitutional rule, maybe next Wednesday I won't bother with it. Or, yeah, Parliament might pass a law, but I intend to disregard it. You know, a little bit of me dies in that moment, because the rule of law is just a fiction that we all believe in. And if we believe that it's a good thing, then we have to also appreciate the fragility of the fiction. And so anyone who uses the sort of language of breaking a constitutional convention or disregarding a parliamentary statute is really playing with fire, given the history that led up to 1946-47.
Finally, briefly returning to this thought with which you ended, really, the quote you referenced, the more we memorialize, the less able we are to remember. I'd like to ask you about your view or your perspective about the relationship between history and memory, or rather, taking your talk seriously, histories and memories, because clearly there is not the history or the memory in the singular. So I'd be curious if you see their work done by scholars as well as literary experts and authors on this notion of history and memory, and how we might see a conflation of the two oftentimes in public discourse or even in scholarship.
Yeah, I do think the question about how to memorialize certain events is a controversial one. It's an interesting question. How exactly do you go about marking a period of atrocity or atrocious political rule? And if we choose trial, it brings with it certain very obvious benefits. We have relatively impartial judges applying the techniques of adversarial law, cross-examination, interrogation of witnesses, a serious-mindedness around truth, and we produce a trial record. And all of that seems like a very good thing. On the other hand, trial judgments are the judgments of lawyers, legally trained experts, judges. And judges are not historians. Judges are not privy to or are not experts in historical method. And one of the problems with war crimes trials, perhaps, is that they seek to provide, or they are said to provide, an authoritative record of what happened. But the trouble is that there are many possible authoritative records of what happened, and it's likely that several records disappear in the moment of one being made prominent or exemplary by an international criminal court. So I think that's one of the dangers of at least conflating history and memory with trial.
Thank you. I think we could continue for some time, but I would like to invite the audience to ask questions and any comments, any thoughts you have about the lecture, about some of the answers that have been given.
Hello. First of all, thank you very much for the presentation. It was very interesting, also in a great location. What I would like to ask is slightly, maybe not directly on topic to what was being discussed today, but it has more to do with kind of two big events also in the last 100 years. First of all, Stalin's purges in early 20th century, and then the kind of great cultural revolution that happened in China, which, when looking at it kind of from an absolute perspective, had a huge amount of casualties. And maybe this has something to do, in my opinion, based off of what you said, this kind of language or this kind of rhetoric that is kind of dual according to which side it comes from, the victors versus the losers, kind of in certain conflicts. But what would interest me, and what I haven't really been able to figure out so far, is that the kind of reaction, kind of the cultural reaction, whether talking about kind of the symbolism that was used in a lot of these movements. You know, for example, you can buy in shops T-shirts with the face of Mao Zedong on them, you know, as if kind of glorifying this individual. Or, you know, the communist parties, even here in Germany, still use the hammer and the sickle as a kind of the symbolism of this communist ideology. And this, to me, is a bit of a paradox when kind of put into context of what actually happened during these periods. And so what would interest me in light of what I would say also are these great atrocities that happened during these periods, maybe you could shed some light on why there wasn't a sort of backlash like in the IMT or the Tokyo trials, why kind of society never really approached these situations with the aim of bringing to those victims some form of justice. Thank you.
Yeah, well, that's an extraordinarily interesting and broad-ranging question. So one part of the question is not really a legal question. It's the question about why we have a different attitude to Chinese and Soviet communism to the one we have towards Nazism. And people have different views on this. One book I do recommend is Martin Amos's Koba the Dread, in which he asks precisely your question. Why is it that people are going around with sort of small busts of Lenin or Mao Zedong or Marx on their desks? Or why is there a whole paraphernalia around communism that people embrace? I was in Berlin yesterday, in fact, and at Checkpoint Charlie, there's all this sort of Soviet stuff. You can buy Soviet hats and little T-54 tanks and so on and so forth. So it's definitely, there's an acceptability around that doesn't exist in relation to Nazism. That may be the cause of the Nuremberg trial, or it may be a consequence of it. It's a bit hard to tease out. Is it the fact that the trial utterly discredited Nazism that makes it impossible to imagine something similar with, say, Nazi insignia in decent, serious circles? I mean, I don't mean that people don't still use neo-Nazi insignia, but is it that Nuremberg created an environment where that became impossible? Or is it because there's something essentially different about the two sets of projects? So that would be a question I don't feel remotely qualified to really answer. All I've done is sort of rephrase the question. But I would say this, that I think a trial of those responsible for the worst excesses of Stalinism might have been regarded as a bit of a serious mistake if it had happened in 1989, 1990, 1991. So there may be moments in international history when trial is just not appropriate, where there may be sort of bigger goals in mind. So that at Nuremberg, the idea of setting out a record to show that Nazism and neo-Nazism would not be tolerated in international society or domestic society was something that seemed very necessary. But in 1989 and 1990, with the Soviet experiment already largely discredited, that might have come across as both unnecessary and unnecessarily punitive. And there might have been dangers in humiliating the Russians in 1989 and 1990 along those lines. It's notorious that Hitler and Goering met at a protest rally against the Versailles Peace Treaty and the proposal that there be trials after Versailles. Those trials would have felt unjust to most Germans, I think, in a way that the Nuremberg trials may not have felt so unjust. I mean, there's a mixed record on that. But on the whole, they were relatively well received, according to at least some historians. So I think there would have been serious risks in convening trials along those lines.
Thank you very much for the lecture. It was very interesting. I would like to ask about the notion of justice, because you mentioned it a couple of times. You posed a lot of questions, but you posed a lot of rhetorical questions. And you mentioned the fact that the Dutch did not extradite Kaiser Wilhelm. And in 2015, we see Omar al-Bashir in South Africa, and he was also not arrested by the South African government. And so you talk about these constitutional moments. Would you say that each of these moments represents a development? We talk of development of international criminal law. Would you say that these constitutional moments represent a development, or is each moment just represents a moment where one political entity is superior over the other? And indeed, you talked about the fact that rule of law is a fiction, but I just want to know your opinion about whether we can really see a real development in ICL, or you sense a form of stagnation.
Yeah, good question. I mean, when I say that the rule of law is a fiction, I'm not saying that in a dismissive sense. I don't say it's a fiction, so we can disregard it. Quite the opposite. You know, when I describe the rule of law as a fiction, I mean to emphasize its vulnerability, not to emphasize that it's beside the point in some sense or other. This constitutional moments idea of yours, Viviane, has really taken off here. It just occurs to me, I've been asked more questions about your question than I have about my own paper. But this is obviously relevant to the things I say. On the question of justice, before I get to your progressive development question, I guess each of these moments, the moment when the Kaiser isn't surrendered by the Dutch to the Allies, or the al-Bashir case, we can have two different views of this. I think there are what you might think of as sort of justice purists around, and there are many of them amongst these sort of international law elites who think that justice is the preeminent ambition in any political negotiation. That if there's a legal principle that requires al-Bashir or the Kaiser to be surrendered, then he ought to be surrendered. And it's a breach of justice or a breach of international law not to do that. And that's wrong, they would say. And then there's a second group of people like Judith Sklar who say, actually, justice is a choice here. Either we have to put justice into conversation with other aims we might have, like, for example, maintaining stability in a particular region, or we put justice into conversation not so much with pragmatic ends, but with other moral categories. And I mentioned hospitality as one of those. An old Kantian notion of hospitality that the Dutch were relying on to hold on to the Kaiser. So here we see justice is in a sort of dialogue with hospitality. And reasonable people can disagree when justice and hospitality clash. You may have a fugitive from justice in your house who arrives in your back garden in a disheveled state. You take her in and you feed her and you discover that the police are after her. What do? Reasonable people would disagree. Some people would hand this person into the police and other people wouldn't. And I think decent people might end up doing both of those things or either of those things. I can imagine a situation where I hold on to the person. They trust me, I trust them, and I decide just to look after them. The main prerogative here is to look after somebody who is in a disheveled, benighted, fragile state, rather than to hand them into the authorities. So I do understand that there are these two sort of views of justice: the absolute position, and a sort of more complex tradition of thinking about justice or situating justice amidst other concerns. Your question about whether international criminal law is developing through these constitutional moments, I mean, I think in one sense it is, in the sense that international criminal law has become much more legal. There's more of it around, for a start. The procedures, the general part of the criminal law, defenses, immunities, all of this is much more complicated, much more legalistic, much more comprehensive than it was when I first started studying international criminal law. So there's more of it about, and it looks more like a criminal law system that you'd find in a domestic legal order. So in that sense, there has been what we might think of as sort of technical progress. But at the same time, Politically, I think history looks much more like an undulation than a progression. So though the techniques of international criminal law are like that, they're heading for some telos, they're progressing. The sort of relationship between politics and law through the history of international criminal law has been a sort of undulation. Sometimes crude politics have dominated, at other times crude law has dominated, at other times there's been some complex mixture or amalgam of the two. So I think it depends, like everything else, on what particular view you take of the word development.
To just briefly touch upon that, you mentioned some of the examples have an international dimension, and some of the examples you used have a clearly domestic dimension, like the Klaus Barbie trial. So I'd be curious there if you see an interplay of the international and the domestic in this century of war crimes trials that you look at, because clearly, I mean, we've seen some scholarship that's saying the future of international law is domestic. In other words, we now, of course, also see a fragmentation possibly of jurisprudence, given that the domestic courts are really taking the lead and doing a lot of pioneer work, especially if we think about the current cases in the Syrian context, where there is no war crimes trials, where the UN has stepped up. There is the IIIM, and now a number of countries, including Germany, on the avant-garde of prosecuting at the national level. Do you see, is there a different quality if it's an international or a domestic trial? Does that have any bearing on the gravitas or on the kind of histories or memories that any trial may create?
Well, Karl Jaspers, who was one of Hannah Arendt's lovers, said that crimes against humanity should be prosecuted in the courts of humanity. So he took a very sort of internationalist view of this. But I think most international criminal lawyers don't take that view or no longer take that position. For me, so one of the things I always say to students at the beginning of, I have about 35 international criminal law students each year at LSE, and one of the things I say at the beginning of each class is that international criminal law is not quite international, not quite criminal, and not quite law. In other words, and to take the first part of that equation, it's certainly not always international criminal law. And if you just reel off the names, the names of iniquity in international criminal law, I don't know, Goering, Eichmann, Barbie, Pinochet, Milosevic, and so on. What you end up with is a mixture of international trials held in international courts under international proceedings and international law, and a series of domestic trials. Sometimes these aren't even trials. Sometimes it's not even international criminal law. Sometimes it's just an extradition proceeding, like the proceedings involving General Pinochet in 1988 and 1999 at the Royal Courts of Justice in London. So my view on this has always been that that's not quite right either, though, that each of these, to go back to your constitutional moments again, each of these constitutional moments isn't really domestic or international. That each of these moments is a mixture or a combination of the domestic and the international. There are always these sort of cosmopolitan internationalist impulses playing out alongside much more localized parochial forms of justice. So Pinochet is a case involving the House of Lords in England applying English state immunity law, but the court also looks at the Nuremberg war crimes trials and the coming ICC statute and so on. The ICC itself, okay, it's an international court, but actually it defers to national courts. It says, look, we only get involved when national courts fail to come up with the goods. So there's a preference built into the ICC statute for national jurisdictions. Or finally, take the Eichmann trial, where the subject matter of the trial was, crimes against humanity, the internationalist face, and crimes against the Jewish people, a much more particular cast. And that, to me, that seems quite appropriate. But international law, international criminal law, is always both international cosmopolitan on one side and local, provincial, national on the other.
Hi, Thanks a lot for your talk, in which you mentioned the difficult relationship between international criminal and international diplomacy, which is quite exciting in public international law in general, I think. So if we make the conscious choice demanded by Judith Schklar for international trials, for war crimes trials, I think we should also make a very conscious choice for the people we pick as judges for those trials. Because some of them have a diplomatic or political agenda, not just looking at list B of the ICC, but also to past trials. We had past trials with military men sitting as judges with not too much judicial experience. I studied law, so at first I'm quite reluctant to non-lawyers sitting in judgment in such important trials. But then when looking at Tokyo, my doctoral research topic, I saw that the defense welcomed Kramer, the second American judge, as being a military man and hoping that he would understand better some military exigencies and problems the Japanese had, which led to crimes. So I'm quite curious about your thoughts, whether you have ever thought about that and maybe the results you found out about judges in international law.
Yeah, good question. I do think there are two slightly separate matters in play here, which you will be aware of. One is the question of technical proficiency, which could be about whether someone has an international law training or a criminal law training or is a judge or is a lawyer in the first place. So there have been lots of questions about that throughout the history of international criminal law. Is this person actually qualified to sit in this courtroom? And given the choice of judges, whether it be at the International Court of Justice or the ICC, is, again, it's a choice of judges, and the choice is often made through a pretty arduous and politicized diplomatic process. Quite often, or sometimes, should I say, judges are not regarded as fully qualified or proficient. That's one problem. The separate problem is that sometimes even highly qualified, proficient judges are regarded as somehow too political, or they're regarded as the wrong sort of judge. They're a military lawyer, or they're not a military lawyer, and that's likely to create a bias of some sort that somebody doesn't like. So I suppose part of the answer to this is to not get hung up on categorizations around this. International lawyers are obsessed with levels. What level is something done at? Is it done at the international level? Is it the domestic level? Is this a military court or is it a non-military court? Is there a representation from this group, the West European group or the African group on the judicial panel? And maybe most of our attention should be asking simpler questions like, is this working? Or is it any good? So to go back to Nuremberg, I was very struck during the period of the Bush administration military commissions. There was a lot of focus on the fact that these commissions were military. Remember, the Bush administration set up military commissions to try those alleged to be responsible for the 9/11 attacks, and this led to Guantanamo Bay and so on. But there was a lot of criticism of the fact that the Americans had set up military commissions. And I used to hear people say, this is totally against international criminal law, which begins at Nuremberg with the, guess what, International Military Tribunal. So when we look back on Nuremberg, and if we look back on Nuremberg with fondness, then we might have to accept that sometimes military judges do a good job, and it may not matter whether judges are military or not. What may matter is whether the job was good or not. But I'd be much more interested to read your thesis than to listen to my answer again. So, good luck with that.
Any other questions?
Thank you again for the very interesting lecture. And I apologize if the question is a bit abstract. You did mention a very interesting sort of perspective during the lecture when you said that at some point there's been a gradual shift where the resistors stopped talking like poets and start talking like lawyers. Staying true to those sensibilities, I was wondering, when the next constitutional movement is identified, and its history written, what would you hope will be a quality or a value that it will fulfill that these proceedings once have failed to possess?
Great question, Louis. Well, I do rather hope that we can maintain what I call a literary sensibility, as you put it, around trials. If we can just, we can understand them as forms of communication in which a lot of different values might be in play. We've talked about the relationship between hospitality and retribution at Versailles, and that we approach these values with a degree of sympathy and candor. And we try and put these values into a relationship that isn't merely technocratic, but is also language-based and literary. I mean, it's hard to... If I was training judges in international criminal law and I said what I've just said, they'd look a bit baffled, understandably, but each comes to their, each comes to the end of their journey in a different way. And I just think that perhaps there could be a bit more of that. And one of the projects I've been involved in while I've been studying international criminal law is the project of getting people to understand what's been lost in the move to judicialization. We hear about the gains of law. The gains are in many ways just so obvious. I'm sure all the visitors who went through the exhibition today were really mainly alert to the gains. They're thinking, well, before Nuremberg, there was none of this. These people would just go off with anything in the international system. You could kill thousands of people, your own civilians. It was just called sovereignty, in fact. And then after Nuremberg, we put a stop to it. And this is a glorious and heroic story. It's told in the genre of the heroic epic. We start off with very little law. We build law from scratch at Tokyoberg. We refine it at Rome, and we apply it to wrongdoers around the planet. This is a great heroic story. There could be a number of other different genres in which one could tell, though, the story of international criminal law without becoming some cynic or perpetual holier-than-thou critic of international criminal law at every turn. So to feel the sort of historical resonance of speaking in this courtroom here at Nuremberg, while at the same time being alert to some of the failings of international criminal law, seems to be the proper position to take on these matters. It just happens to be the position I take too, so.
On this note, I think, of historical significance, maybe one more question and then we'll have some closing remarks.
So when looking into the Tokyo tribunals, you see many of the Japanese scholars criticizing the tribunals, say it was mainly victor's justice, and that if you compare to the penalties that were actually applied in Nuremberg and the ones applied in Tokyo, there's a difference, and they say they were much more strict in Japan, and they say this was basically a racist tribunal, and that it was from a Western point of view that didn't take the Japanese and Asian background into consideration. Nowadays, with the ICC, we also have similar accusations towards the focus of the court on African countries, and many argue that until nowadays, international criminal law is basically done from a Western point of view, and it doesn't take into consideration cultural sensibilities and specificities of each region of the world. So what are your thoughts on those claims? Would you say this victor's justice in Tokyo, and what would you say about the criticisms towards the ICC today?
Yeah, this is a really very sensitive matter. To go to the ICC point, I remember being on a panel with Luis Moreno Ocampo, and it was going very well. And then there were about 300 or 400 people in the audience at the LSE, and I noticed that no one had asked him anything about the defendants and the African focus of the courts. I thought, I better ask that question because it seemed like my duty as a chair, and everyone's curious about it. And I asked it, and he was quite enraged by the question. He accused me of being a northernist, which is I guess it's a kind of variation on Western imperialist, whatever it is, for demanding that the ICC not look at Africa somehow. So it's a sensitive matter. I guess one way to think about institutions is and this goes back to conversations that were taking place in Berlin this week on cynicism in international law, is that sometimes people who continue to act virtuously and neutrally and have pretty good racial politics within institutions can still produce institutional outcomes that look heavily racialized from the outside. So I would say that. I'd say it's not always about intentionality, but to look at what the ICC is doing right now, if somebody arrived from Mars and considered what the ICC was doing, they might say, what's this about? You know, it's a sort of simple question. It's a sort of childlike question. And I think it's often useful to hold on to a sort of childlike bearing in these matters. Say, it's a funny system of law you've got. Most of your defendants are like this, and none of your defendants are like that. Why is that? So I think it's not doing the credibility of the ICC much good. Whether it's got a parallel with Tokyo is a tricky one. I mean, in some ways, Tokyo, I've always described Tokyo as a form of victim's justice, partly, rather than victor's justice, in that the victim states like the Philippines, China, India, had judges represented in the court, and the dissenting judgments of people like Rowling, the Dutch judge, and Justice Paul, the Indian judge, are really powerful moments in the history of international criminal law. So I can see the flaws in the Tokyo war crimes trials. I've heard Japanese scholars talk about this over the last 15 to 20 years. But I've also thought of Tokyo as having a redemptive quality. It's probably too early to really tell whether the ICC judgments around Africa will have a similar redemptive quality or not. Maybe the acquittals will be thought of differently. They'll be thought of as a bit like Paul's dissents at some point. Who knows?
Thank you very much. Are there any final questions?
Thank you very much for the very interesting lecture. My question is back to the concept of justice. The development of international criminal law, and historically, it's very undeniable. And the concept of justice, as you mentioned before, is the retributive justice. Now we see the latest years, this concept, especially in countries that like Afghanistan, Iraq, and Syria, this concept maybe countries, they have more of national problems. If we go after those criminals and perpetrators, it may create some problems in terms of their peace. And it showed somehow that peace is somehow interrupted. And one of the aims of the humanity may be also living in peace, and peace as one of the goals of the United Nations. It's a very important and central concept. So do you think that this concept of retributive justice is somehow, we can reflect on that and say maybe there's an alternative, or maybe we should maybe focus more on restorative justice, or what do you think about the whole developments? Because now if we look at the history, the wars are more of international nature, but now it's a very complex situation. The wars are very different, and oftentimes they have a national kind of characteristics. So what do you think generally about this? Thank you.
One of the sort of presiding ethos of international criminal law has been to regard national matters as international. So one of the projects of international criminal law since the beginning of the 20th century has been to take matters or circumstances that once looked local and national, and to describe them as matters of international concern. That's what the UN Charter does in Chapter 7. It's what the Nuremberg War Crimes trials did. It's what Article 6 of the IMT Charter does. It strongly suggests, for example, that events taking place in Germany before the war were of relevance to international criminal law, and events that took place exclusively in Germany were of interest to international criminal law. So it took the local and turned it into an international matter. That's what international criminal lawyers have done. So they wouldn't be put off by the fact that some issues look very national from certain perspectives. But your question about restorative justice is interesting because in criminal law and criminology in places that I've worked and studied, like the United States and Australia and the United Kingdom, there's been a shift from retributive justice to restorative justice, at least in theorizing about crime and punishment. Why send people to jail? They're not going to be rehabilitated. It doesn't deter anyone. There are different ways of doing this. Let's send them out for community service. Let's give them counseling. It moved to all sorts of rather clever ways of achieving non-retributive justice through restoration or restorative forms of justice. And we've seen a little bit of this at the international level as well, in South Africa with Truth and Reconciliation Commissions and so on. But on the whole, international law has gone in the other direction. If you like, international law used to be all about restorative justice. There was no retributive justice. There were no international criminal tribunals before 1945. So it was all restorative in those days. We've taken the opposite journey from domestic lawyers, in other words. We've gone all retributive, and we've become very excited about that. You can sense it in conferences or even at dinner parties. People will say, hey, this international law thing you do, it's great. Somebody got imprisoned last week, or they executed a guy in 1946. This is a real form of law. It's doing the sorts of things we associate with real law. It's putting real human beings in jail, or indeed hanging them back in the 1940s. But this was a slightly strange move for international law to make, given all this criminological study at the domestic level. And I think what's happened now is that there's probably been a bit of a backlash against this project of criminalization, and we may move back to different forms of restorative justice. I think that some of the debates around the ICC in Colombia and so on are precisely debates between retributive and restorative forms of justice, and they're playing out around the concept of complementarity in the ICC statute.
Wonderful, thank you ever so much. I think I would like to take the opportunity to thank you ever so much for this, very eloquent and exquisite journey that you've taken us on to see some of the silences and some of the blind spots, as well as decentralizing or decentering the oftentimes narrated story of international criminal law, and this in this very room has been absolutely remarkable. So I'd like to all of you join me in thanking Professor Simpson for this very inspiring, insightful lecture, as well as the discussion. Thank you ever so much. It's been a great pleasure. Thank you.